Test, test. Test, test.
Test.
Appreciate everybody being here today. I'm going to go ahead and call this meeting to order. Could we have a roll call, please?
Hooton. Epps. Chapman. Gill.
Yes.
Hampton.
Here.
Uyghur. Williams. Present.
Okay, thank you. Thank you for that roll call. The mayor and the mayor pro tem won't be able to be here today. They had some prior responsibilities they had to take care of. There is an order of business that we have to take care of. Tim, please.
Pursuant to our council policy 1-6, when the mayor and mayor pro tem are not here, the most senior council member calls the meeting to order. That was Councilman Hampton, and that's been done. So at this point, though, the council that's here needs to make a motion to elect a fellow council member to preside over the meeting.
Could I get a motion, please?
Yeah, so moved.
With motion, what was the motion?
The motion is that you step in as acting chairman for this meeting.
Okay, thank you. Could I have a second? We have a second and a vote, please.
Hooton. Gill.
Certainly.
Hampton.
Yes.
Uyghur. Williams.
Yes.
Okay, thank you, and that motion passed unanimously. With that, we'll go ahead and go to item number 1. Receive training from the city's disclosure council on the city's disclosure responsibilities related to the city's issuance of bonds and et cetera. Under the federal securities law, including Securities and Exchange Commission guidance for council members, overview of disclosure procedures and disclosure standards, and distinction between liability of the city and liability of the individual council member. Brian Garzione, sorry about that, Brian. Brian Garzione will be speaking for us, but I'm going to hand it over to Tim. Please, Tim.
Thank you, Councilman Hampton. Just before we begin, so the audience and council members will be aware, we have a council policy 2.9, which is municipal securities disclosure policy, and that policy requires every 2 years that we have training for staff and for the council. This morning, staff had its training, and so this afternoon is training for the council. And why this is important is because the city, as a governing body, we issue GO bonds that voters approve, and those GO bonds are placed on the market, and investors have a chance to purchase those bonds. And as part of that process, there's disclosure responsibilities when we go on the market, and staff works to adhere to those responsibilities, but also there's responsibilities for the governing body too. And so Brian Garzione is our disclosure counsel. He's out of Washington, D.C., and he's going to be giving a presentation this afternoon to the council on our disclosure policy and how it affects the elected officials. So at this time, I'd introduce Brian Garzione.
Thanks, Tim. Thank you, everyone, for being here today. So, as Tim mentioned, what we're going to do here is we're going to go through this slide presentation and set forth disclosure responsibilities under the federal securities laws. This presentation sets forth, at least, initially, just a reminder of what the key city disclosures are when the city is either entering the market to sell bonds, such as the preliminary and final official statements, and then some other, what we'll call secondary market disclosures that happen periodically throughout the year while the bonds are outstanding. Those would be the audited financial statements of the city, and certain annual reports and material event notices that are required to be posted on a periodic basis based on a contract called the Continuing Disclosure Agreement. Each of those items I just mentioned are filed on a website that collects municipal securities data. That's called EMMA, and that's a national document repository that houses all of this information. And that's part of the continuing disclosure agreement will require posting on that website. Some other documents there listed speak of closing documents and other presentations. Those may be used for purposes of selling the bonds, but they're not posted on that document website that I mentioned. So, speaking of the official statement, the official statement is the document that the city will use to sell bonds to investors. And as Tim mentioned, those are often prepared in connection with the city's general obligation bonds. And those documents are prepared by the city and then provided to investors. The investor needs that information to decide whether or not to buy the city's bonds. And in that document will be a comprehensive presentation of all factors that could affect the ability or willingness of the city to pay principal and interest on the bonds when due. So, as we put together the document, we know what it has in it. It's all the information. It talks about the bonds, what is the security for those bonds, how will they be repaid. It has in it all this information about the city, the financial condition of the city, some information about the demographics of the city, other budgetary information about the city. Some of that stuff, all that information is compiled into the official statement. So who's involved in putting it together? The city council will approve the official statement. The mayor signs the official statement. And the disclosure working group, which consists of individuals that we were talking with this morning, approves the form and the content of the official statement. City management and staff, again, part of the training that we did this morning, they'll be providing the information needed to draft the document. And then there'll be third parties involved, financial advisors, bond counsel, underwriters, if there are underwriters on a deal, their counsel and disclosure counsel as well. So, now that we're giving this presentation this afternoon to the city council, and what goes into a city council action with respect to an official statement. So, a typical city bond ordinance will say something to the effect that the official statement pertaining to the bonds is hereby approved. So, when doing that, the city council is deeming the official statement to be hereby approved, in the content attached to the ordinance. Essentially what that means is that the official statement is true and correct as of its date, and does not have any untrue or misleading information included in there. What that means for purposes of the official statement is that the document that you all see and approve is what ends up being sent to the investors. Now, there may be a situation where the official statement has some information that needs to be filled in, some pricing information, some information about the interest rates or a bond yield, that stuff that may come in after council approves it, but that those are things that we call pricing data that comes in as of the pricing date, which will often happen after the approval of the official statement. So just a little overview of the training. We're going to talk about the basis for approval of official statements, the SEC's guidance for council members. We'll talk about the disclosure procedures and the disclosure training. And then we'll distinguish between the liability of the city with respect to information included in the official statement and the liability of the council members themselves. And then we'll briefly get into disclosure standards and defense to liability. So the SEC, and please, if anybody has any questions as I go, please feel free to jump in. The SEC has some limited jurisdiction in the municipal securities arena. Securities, before they're sold, would need to be registered with the SEC, and that applies to all securities unless there is an exemption. Municipal securities have one of those exemptions, so the whole securities registration regime doesn't apply. But what does apply is this concept of anti-fraud provisions. And we'll get into a little bit of that in a moment. What is regulated more directly is the activities of the broker-dealers or underwriters and certain advisors. So that's something to keep in mind, that the SEC has direct regulation over certain participants in a deal, but they don't have that direct regulation authority over the issuer, such as the city itself. This slide sort of refers back to what we talked about in the beginning. The disclosure contexts mean when this disclosure is made, right? Primary disclosure is when the bonds are first sold. That's the preliminary and final official statement. When you're speaking to the investor, presenting the bonds to be sold, the projects that they will be supporting, and they'll make a decision on whether or not they want to buy those bonds. The secondary market or secondary disclosure concept is while the bonds are outstanding, things that the city agrees to provide on an ongoing basis. And those would be the continuing disclosure agreements entered into pursuant to Rule 15C212, which we'll talk about later, and any voluntary filings that there's no limitation as to voluntary filings. So if the city decides that there's something that the market should consider, it can do that away from any requirement. And then there's this concept of information that is reasonably expected to reach investors. That's sort of the SEC's catch-all for lots of different statements that could be made by the city or its officials. Rule 15C212, this is a rule that is regulating underwriters directly, and those underwriters who are being regulated by this will pass some of this regulation on to issuers through a contract, and that is where you'll enter into the continuing disclosure agreement, and that allows the broker-dealers to comply with this rule. Essentially, what the underwriters are required to do is determine that the city will provide that annual information and notice events while the bonds are outstanding. The concern that would be if the city were not to comply with its ongoing continuing disclosure obligations, underwriters may not be able to reach a reasonable determination for future bond offerings. So that ongoing compliance with respect to the continuing disclosure agreements is very important for purposes of maintaining access to the capital markets.
Question.
Sure.
With the Councilman Uyghur here, with regard to the audits, you made mention of the audits and their impact on the issuing of the bonds. How great of a role does that play, just so we understand?
Yeah, I mean, it's a piece of information that is attached to the most recent audit would be attached to the official statement and considered by investors when making a decision to buy a bond. In terms,
I'm
go ahead.
So a current audit will get you a higher interest rate than a audit that would be behind, correct?
Well, no, I mean, I think it would have the opposite. I mean, so interest rates, from the city's perspective, you want the lowest you can get. So it kind of works in the opposite way. Having a current audit and being up to date on continuing disclosure would theoretically have an effect to lower the city's interest rates for borrowing.
Thank you.
Yeah.
Yeah.
So there's, in terms of, the Rule 15C212 talks about the continuing disclosure obligations of the city. And we talked about how that would translate from what is in the official statement to something that's provided on an ongoing basis. A disclosure standard is conceptually something that applies whenever the city speaks to the market. That could be with the primary offering document of the preliminary official statement, or it could be through continuing disclosure filings as well. And what this disclosure standard is telling us, Rule 10b-5 is the one that folks here are most familiar with. And this has to do with making it unlawful for any person to make an untrue statement or omit to state a material fact whenever they're selling a security. Essentially, you must be providing true statements, and you can't omit something that was, a material fact necessary to make the statements in the document not misleading. So essentially, what you're talking about here is making sure that whenever you're using a document for purposes of speaking to the market, that it has true statements and doesn't omit material information. What is material? That is something that is derived from case law through SEC enforcement actions. Something is deemed material if there's a substantial likelihood that a reasonable investor will consider it important to an investment decision. It's a lot of words for something as brief as quote-unquote material, but essentially it can be boiled down to, would the investor want to know this before decided to buy the bonds? And that is not always the easiest thing to point out in advance. It has to be something that you examine under the facts and circumstances of that particular issuer and particular matter that you're considering. If the SEC does bring an action, they can bring it against the issuer itself. They can bring it against individual members of the city council. That one is what I would call theoretical. We have no examples of that to date, but it is a theoretical possibility. The SEC could bring an action against government officials and third parties. So if we're looking at this slide, the first bullet and the third and fourth bullet, we have several examples that we can point to where the SEC brought actions against those individuals. With respect to members of city council, we haven't had one of those. We have had one example where the SEC provided some guidance on how members of a governing body can protect themselves, and we're going to get into that in a few slides. Just as a brief overview of what litigation could be from the SEC side, it could bring an administrative proceeding. That is what most of their cases are. Those are quasi-civil proceedings. So the first two sub-bullets there, administrative and civil, pick up 90% of the SEC's litigation. They can bring criminal actions. Those would be brought by the Department of Justice after a referral from the SEC. There's also a theoretical possibility of private plaintiff actions, but they are very rare and infrequent. So if there were to be a SEC enforcement action, it's going to be one of these items here on the slide, either a 10b5 action under the 1934 Act. The SEC has to prove intent or recklessness there. Harder for them to prove those. So most often, the SEC brings Section 17 actions under the 1933 Act. Those referred to here as A2 and A3. All the SEC has to show there is negligence. It's a much lower standard, and it's much easier for the SEC to succeed in those proceedings. So most of the cases are 17A2 or 3 negligence cases. So as I mentioned, we have one SEC matter to draw from when it comes to guidance for members of a governing body. And this had to do with the Orange County, California case from several years ago now, 1996, or we're pushing 30 years. The Orange County case involved essentially a bankruptcy for the county. And it was a source of lots of market turmoil at the time, and the SEC focused very, very closely on who knew what and when. The Orange County report that came out after the investigation was over basically said, well, while we're not taking any action against the members of the governing body, here's some useful guidance on how to protect yourselves. So even though that case did not result in any charges against the members of the governing body, Orange County is often cited to this day as the main piece of authoritative guidance on how to really steer clear of the SEC when it comes to matters or members of the legislative body. Orange County report told us in 2 places that it reminded us the public official may not authorize disclosure that it knows to be false. So, alluding back to what we talked about in the beginning, city bond ordinance says, that the city council is hereby approving disclosure, the official statement. So you can't authorize something that you know is false. Okay, that's pretty clear, right? But you may not authorize disclosure while recklessly disregarding facts that indicate there is a risk that a disclosure may be misleading. That's a little messier of a standard. So we have to probably focus a little bit more on that second bullet than the first. So what is acting recklessly? So the Orange County report told us that public officials, if they have knowledge of facts bringing into question the issuer's ability to repay securities, they have to raise them. If you don't raise them, then that could be evidence of acting recklessly. Also, another example was failing to take steps appropriate under the circumstances to prevent the information to prevent the OS from being distributed with that false and misleading information in it. So if they know something is incorrect in the official statement, they have to take steps to prevent that document from getting out. So it's essentially a 2-pronged test of, do you know something, and have you raised it? And then if you haven't, that's when we run afoul of the guidance here. So the guidance that they gave us, the SEC gave us in the Orange County report, was, what can we do? Essentially, everyone would be in agreement that we're not trying to act recklessly. So what can we do? The steps that you can take to becoming familiar with the disclosure documents, and then questioning the issuers the officials, employees, and other agents about the disclosure of certain facts. So essentially, becoming familiar with the document before it's mailed and before it's approved, and then asking the financial staff, can you elaborate on certain items in the document and how you were to reach those conclusions? So the reality is that the city council needs to have some alternatives. They can read the official statement as a whole and get familiar with it, comfortable with it, ask questions if they need to, or they can establish reasonable reliance on the financial staff, the folks that we mentioned earlier who received their training this morning. You have to, notwithstanding establishing that reasonable reliance, you have to make sure the city council could be aware of something that the financial staff is not aware of. And if that is the case, they should, there should be some discussion about how to raise certain issues with the financial staff of the disclosure working group in order to make sure that those matters are flushed out. And then what we're going to talk about next is this reasonable reliance concept and how that can be implemented. And that's the disclosure process and the disclosure policies and procedures. One of the things that we'll want to stress here is that the disclosure process is meant, or the disclosure policies, excuse me, are meant to establish this reasonable reliance on the staff and the folks who do the legwork in preparing the official statement. So that the policies and procedures that we have in place, that the city has in place, establishes the disclosure working group, and it created this position called the disclosure coordinator. And the disclosure working group is listed there. This second to last bullet, supervisor of financial services, has been eliminated. So that's no longer a member of the working group, and we're going to revise the policies to reflect that. One of the things that the policies mandate is the training for city staff and council. It's conducted every other year. Part of the policy is this Appendix A, which lists a variety of disclosure documents. And that's meant to be a broad definition so that this whole universe of disclosure documents is reviewed by the disclosure working group on a regular basis before those items are either published or provided to investors. There's also an annual review of effectiveness of the policy, and that's meant to make sure that the policies that you have are being followed, and if they aren't, if there's something that's not working, those can be revised. The worst case scenario would be you have policies, something goes wrong, the SEC looks at your policies and say, why didn't you do these things? That's sort of that's a bad fact that you wouldn't want to have. So the idea of an annual review is to make sure that what you have works for you and that you're following them. So for city council, you should be thinking of certain oversight questions when you're providing that approval of an official statement. Those questions here on this slide, you ask yourself, am I satisfied that the process followed in preparing the document are reasonably designed to produce accurate, reliable information? Do I have reasonable basis to have confidence in the integrity and competence of those members of the working group or the disclosure working group? Do you know of anything that would cause you to have any questions about the accuracy of the disclosure? And if there are, any risks that the disclosure is, misleading? And are there any red flags? So certain things like labor negotiations, litigation, pension funding. Those are all examples of things that have come up in SEC enforcement actions that sometimes City Council may know about developments in those areas before the working group does. And if there is something like that, have you raised it with the working group? So, in summary, one of the things just to take, as a takeaway, is remembering that there are various contexts of disclosure. It could be the primary offering document, and it could be continuing disclosure documents filed annually or periodically. They could be voluntary filings, and they could even be certain certifications relied upon by bond counsel for tax exemption purposes. Just recognizing how varied the disclosure context can be.
Brian?
Yep.
One of the council members asked me a question on your presentation about what we're talking about disclosing information, and is that the lack of just failing to disclose information or disclosing too much information? And when we're talking about, so I'm posing that. He asked me to pose that question to you.
Sure. So I think for the most part we're talking about not disclosing, where there's an absence of disclosure. Those types of areas, when there is an enforcement action, the SEC has a much easier job when something happens and they hold up an official statement or a disclosure document and say, look, you didn't mention this thing at all. In the same vein, there can be a scenario, and I'm not thinking of one off the top of my head from an enforcement action, but at least a theoretical concept could be that there's too much information in here, and the investor is just inundated with information, and actually, as a result of that, is unable to really focus on the key items it needs to focus on when determining whether or not to purchase a bond. So, I think I wouldn't want to say that the standard should be disclose everything under the sun, because there could be the concept of having too much information could result in not having a focused enough document for an investor. But most of the time, the vast majority of the time, we're dealing with disclosure issues that have arisen from lack of disclosure. On this slide, just a summary of the standards again. We're dealing with materiality. If something isn't material, it's clearly not material, it's not an issue. Because what we're dealing with is materially misleading information or material omissions from a document. So if there is a determination that this is so minor that it doesn't warrant disclosure, that's fine. So just something to keep in mind, it isn't everything. It has to have, there is a standard. Materiality is the standard, but it's just not a bright line test where I can tell you this is always material and this is never material. It has to be under the facts and circumstances, but if something is determined to not be material, there really doesn't need to be anything in the document about it. The legal standard for the SEC is in order to bring an action, they're going to have to prove one of these three: negligence, recklessness, or intent. Most of the cases, as I mentioned, are negligence cases because that's a lot easier to prove. Recklessness and intent are similar, and they're harder. There has to be, most of the time, those cases have to go to a judge or a jury for a fact finding of that type of level of thought in terms of the recklessness or the intentional fraud. Very infrequently, those cases will have settlements when they're that high of a standard. The negligence cases oftentimes will start out as a complaint and a challenge by the defendant to say, I didn't do anything wrong, and there'll be a settlement of the negligence standard, under the negligence standard, once they realize that it's fairly easy for the SEC to prevail. So what steps can City Council take? The steps are, what steps does the city have to approve and implement disclosure best practices? Talk about the framework for council review and approval of disclosure documents, the processes and guidelines to establish a defense to the charge of negligence or recklessness. Like I said, most often it would be a negligence defense. Policies and procedures in and of themselves have been used as an example by the SEC in a variety of enforcement actions as defenses to the negligence charge. So in a couple of SEC enforcement actions, there'll be a settlement with, let's say, an underwriter. And in the settlement papers, there will be a discussion about why the issuer had not been charged or part of this settlement. In a few instances, that summary will say the issuer is not part of this proceeding because they had policies and procedures in place, and that established their defense to a charge of negligence. So there have been several SEC enforcement actions with that fact pattern in it. That's the end of the presentation. I'd be happy to take any further questions that folks have.
Okay, is there any further questions from the council?
Yeah, Brian, we want to thank you for taking your time to bring us this real important information. It certainly is meaningful and something that we'll really take to heart. I also want to thank any of the other people that had a part in bringing this information to us. I know that it takes time to do this. The council, does anyone else have any questions or comments? Okay, go ahead, Tim.
Okay, Brian, just real quick, I want to, again, also thank you for the presentation this afternoon. I'd like to say to the council that the continuing disclosure obligation that the city has is something city staff takes very seriously. With the council policy that Brian mentioned that you have approved as a council, we certainly do our due diligence. We meet as necessary when we're doing these offerings. We go through the data each year. The working group meets when we have to do our continuing disclosure update obligations, and we do that, and when we take it extremely seriously. We have a continuing disclosure coordinator, as Brian's mentioned. That's Cindy Augustine. That's one of her main jobs is to make sure our filings are done timely, and to work with Emma. We'll work with DAC. That's another company that we hire that helps us with our filings. We also want to, again, thank Brian because his law firm, Hawkins Delafield, this is one of the main things they do, and they are one of the experts in this area, and he helps us when we're doing reviewing preliminary official statements, and when we have questions, we will certainly reach out to him, and just so you know that we do take this very seriously.
Okay, thanks again, Brian, and everybody else. I need a motion to adjourn. Second. Call the roll, please.
Hooten. Gill. Hampton.
Yes.
Uyghur. Williams.
Yes.
We stand adjourned.
Thank you, everyone.
Thank you, Brian.
Bye-bye.